This is the second half of the third cassette on basic federal practice, the essentials of civil pretrial procedure in federal court.
Let me ask just quickly before we leave it whether either Boris or Doug have any comments on status conferences before we move on to the topic of pretrial conferences, the final pretrial conference before the trial.
The only comment I would have is that some lawyers have a tendency to take the status conference not very seriously and send a very young lawyer there, somebody who really isn't going to be handling the case. And I think that probably the most senior person, the person who's going to try the case, should show up for that. That's really your first shot face-to-face with the judge in a lot of cases. And you need the judge to start associating your face with that litigation and start hearing your story.
I agree with that. Final pretrial conferences. Doug's going to talk to us about how you get ready for a final pretrial conference. Is really a significant, substantial, and very important event in federal pretrial practice. Douglas?
By this time, you've been to all the status conferences. Your face is well known to the judge, the magistrate, the judge's courtroom deputy. It kind of feels like old home week when you walk into the courtroom, and the final push towards trial begins. There are some who think that this is the final pretrial conference is an effort to exhaust the trial lawyers so that they'll be easier to handle for the judge by the time they get to trial. And I assure you, if you've been through one of these things, it is an exhausting experience. But the truth of the matter is, it's also an experience that helps that trial to be much better conducted by everyone, because in federal court, unlike anything you've ever seen in state court, everything that will happen in trial is covered in the final pretrial conference stages. It is a very significant event, the final pretrial conference. It's underscored by the fact that it results in an order that supersedes all the other pleadings in the case and will govern the issues and the evidence that comes in at trial. So it is of paramount importance by the time you get ready for trial. Look at Federal Rule of Civil Procedure 16 and Local Rule 235-7. These are the two primary rules you want to look at in preparing for the final pretrial conference. The final pretrial conference, like the status conference, but even more so because of this final order that enters, is an opportunity to trim the issues. It's an opportunity to expand the issues based upon the proof that has been presented. And it's an opportunity to obviate or deal with evidentiary problems that you may see coming in the case. And it's also the opportunity for some real advocacy, because with pre-planning, if you present a document that has some advocacy elements to it, you may find that even at this stage, the judge will turn to one side or the other and say, I would like you to make a motion for summary judgment on either the whole case or all of the issues. And to that end, I'm going to continue the trial. I'd like you to have your briefs done on this date and the opposing briefs done on the other date. Or, as Steve has suggested, sometimes happens at the status conference statement, the judge may turn at the pretrial conference phase and actually make one side or the other put on what is in essence an offer of proof. What is it that you will show me at trial on this issue? And in at least one instance I know of, a judge at the pretrial conference, sua sponte, entered summary judgment against the party who failed to respond to that, and it was upheld by the Ninth Circuit. So this is not something that you can walk into idly. Preparation for the pretrial conference is very, very important. All right, it begins well in advance of the trial, but at least 20 days before the conference, it is required that both sides meet and confer and talk about two things: settling the case and drafting a joint pretrial conference statement. Both of those things have to be covered in this meeting. Settlement can be a perfunctory issue if, in fact, it's a case that simply has to be tried. But in the pretrial conference statement, you must certify that you have, in fact, discussed it. The drafting of the pretrial conference statement itself is a major event, and it is due 10 days before the pretrial conference. So, tip number one is, if you wait until 20 days before the pretrial conference, you are giving yourself an awful lot of work to do before the pretrial conference itself, because you only have 10 days to produce a major document. Let me give you a sense of some of the things that have to be covered in this document, and you'll know why 10 days is not enough. I'm referring to Local Rule 235-7. It covers some things that maybe aren't so difficult to talk about in every case, such as the parties, who they are, and whether in jurisdiction and venue and so forth. But then it gets to some things that are rather difficult. It talks about, for example, are there any undisputed facts? What are they? Are there disputed facts? Tell me what those are. Exactly, if you're the plaintiff, what are you asking for? If you're a defendant, exactly what are you asking for by way of defense or by counterclaim or whatever? What are the points of law that the judge is going to be faced with in the case? This is a concise statement of each disputed point of law. The judge is not at this point asking for briefs on this issue, but is asking for a concise statement with reference to statutes and decisions that you're going to rely upon. The judge at this stage wants to know a list of all the witnesses that will be called to trial, except those that will be called for rebuttal purposes. So already, you've got to know who you're going to call in the case. And you need to know why they're going to be called, because for each one you have to give a brief statement describing the substance of the testimony that each witness will provide. So there's not really much room here for hiding the ball. You must know early on what your witnesses are going to say. How about exhibits, schedules, and summaries? Yes, those have to be addressed in this statement as well, except those, again, that you will use for impeachment or rebuttal. So you have to give a brief statement following each one, describing what it is, describing the substance, and the purpose for which it will be used, and the name of the witness that will sponsor each exhibit. You have to talk about whether the case should be bifurcated for any reason, whether special experts should be appointed, exactly how long you expect this trial to take. This is important. The judge is trying to keep a calendar moving, and they expect a good faith estimate from counsel. And be aware that some judges will lean on you very hard at this stage. Even one judge who will require, for example, that putting people on direct examination will simply submit their testimony in writing and have the witness available live for cross-examination. Are there any claims of privilege or work product? Those have to be described as well, and exactly what they are and the substance of them. So 20 days before trial, if you begin to address both sides, these issues, you're really putting a tremendous burden on yourself. So how to prepare for one of these? One is to look at the local rules early. To begin looking at the pretrial conference statement, I would suggest is something you should do at the very beginning of your case, because you should be honing your case down to be able to address all of these issues well in advance of trial. Consider the case and consider exactly what issues should stay in the case and what issues can now be taken out of the case. Remember that there is a statute, 28 U.S.C. section 1927, that authorizes sanctions against attorneys who unreasonably and vexatiously multiply the proceedings. I haven't seen this used very often, but the point is that just as you would trim a case for trial and put your best foot forward in front of the jury, so you must do it in the pretrial conference statement, otherwise the judge will do it for you. You have to evaluate your witnesses. Who will you call? Why will you call them? Because it just has to be addressed in the pretrial conference statement. You really have to evaluate your evidence and the foundations for it. If you think there will be any reason why you may have evidentiary problems or why the other side will have evidentiary problems, it's almost too late at this stage to deal with those issues. But if you have any chance of salvaging it, it will be at the pretrial conference stage. And finally, be sure that your witnesses will be available at trial. This is the last opportunity you will have to tell the judge that there may be some reason to maybe have the case continued or have issues bifurcated or something unusual done in the conduct of the case. You can do that, of course, during the trial, and you can do it on day one, but the judge will be less receptive to it if he or she knows that you had the opportunity at the pretrial conference and didn't do so. One final thing to consider early is whether you'll have any unusual evidence to present. We've had a case recently with a musician who had to come into court and play some of his music for the jury. And the judge needed to be told that we're going to have someone in here with a guitar playing music to the jury. And if that doesn't exactly lend itself to question and answer format, Judge, this is what I intend to do. There have been cases where TV monitors have been present and people